Good afternoon to all of you. I am Christian Zeller, Nmsu's Immigration Counsel, and welcome to our biannual visa workshop. Good afternoon, I'm Christian Zeller. This is our biannual visa workshop for Nmsu. Normally we have those live on campus, but since the pandemic we have gone online, and that's a great solution. It's working just fine for everyone. I am broadcasting from my home office in Florida today, and I also want to let you know we are recording this session. But a word of caution to that, I'll send out the recording. It'll be accessible to all of you and your friends whom you want to share it with. But keep in mind that immigration law is a moving target, and things keep on changing constantly. So please, before you act on anything that I'm about to say today, check back with me again whether it has changed. In addition to that, I want to let you know that this is, of course, your afternoon and not mine. So if you have questions, I really want to entertain those. On your screen, you have a Q&A, so you can go into the chat and ask a question. I'll be happy to answer that. Or if you would like, raise your hand. You should have that function on your screen as well. And I will let you talk, and then the entire group can hear your question, and we can have a conversation about the issue that you are raising. So with that, I suggest we get going and let's see what happens. So first, I want to give you an update on the COVID-19 travel restrictions and visa appointments overseas. There haven't been any changes since we spoke last with respect to travel restrictions in order to enter the United States as a non-immigrant, such as with your student visa, with your H-1B visa, with your J-1 visa, or whatever other visa you might have. You must have a negative COVID test, and you must be vaccinated against COVID-19. If for one reason or another you cannot get a COVID-19 vaccine, you have to have proof that you have some acceptable medical contraindications against COVID vaccines, but that's really the only exception that applies in this context. Now, a word to visa appointments overseas. I know many of you already have visas and you're stateside with those visas, but sometimes you're stateside, and while you're allowed to stay, your visa expires, and then when you go home on vacation for the summer or for Christmas or whatever the holiday may be, you want to renew your visa. A word of caution with that. Our embassies and consulates have been closed for quite some time, so they have a tremendous backlog on all visa issuance. And even though H-1Bs and J-1s and F-1s are on a priority list, you got to figure out ahead of time whether that appointment is going to work out for you or not, because potentially you could be stuck overseas for a month if you don't make the proper arrangements ahead of time. So just to bring it up, so that's what you want to know. And with that, let's dive into our visa situations. I'm very pleased to report that, of course, you know that already, that Nmsu has a number of STEM degree programs that are offered there. And with STEM, of course, your OPT after you graduate is way longer than the regular OPT. So what you can do in order to get the 24-month STEM extension on OPT, you have to be in valid OPT when you apply. And I can't emphasize that often enough. If you wait until your regular OPT, the one-year OPT that you have, if you wait until that expires, and then you apply for your 24-month extension, you will be denied. So you have to be able to apply timely, meaning you got to apply for your STEM extension while you are in valid OPT. And then, of course, you got to have a STEM degree in order to do that, but you don't have to have earned that STEM degree at Nmsu. You can have earned that STEM degree anywhere. And in fact, if you earned a STEM degree previously, as far back as 10 years, you can utilize that STEM degree for a 24-month STEM extension. So that's a pretty good gig, actually. Now, I'm very, very pleased to report that NMSU is actually a STEM employer, because NMSU has on occasion hired STEM graduates because NMSU is an E-Verify participant. And I want to spend a minute on that, because if you're a STEM graduate, you have to understand what that is. E-Verify is a collaboration between the Social Security Administration and the Department of Homeland Security, which allows an employer to check online whether a prospective employee is actually work authorized in the United States. And that's really not a bad thing. It's actually very, very convenient for employers. But the part that you need to know is that in order to get a STEM extension, your employer must be a participant in E-Verify. And even though E-Verify is voluntary for employers, in order for an employer to get an OPT STEM applicant employed, they must be members of E-Verify. So when you do have that job offer, wherever that may be, please do find out right up front whether that company is a participant in E-Verify, because if they are not, they cannot employ you for your STEM extension. Now, the other thing to know about working for a STEM employer, there has to be a proper employer-employee relationship. That means that if you're a STEM graduate, you can't be self-employed. You know, with your regular employee, with your regular OPT, you actually can be self-employed. You can open up your own business. It's not a problem at all, but not for the STEM extension. You have to have an employer. Any material changes in your STEM program have to be reported to the DSO. That's really, really important, because you know that the STEM program is really a training program where you are not replacing a current US worker. So a training program is something where you are taking on an additional responsibility, your training at that employer. And changes in that training program must be reported to your DSO at NMSU. And I tell you this because more and more we see the Department of Labor and the USCIS doing audits at STEM employers. And then, of course, if the STEM program says one thing and you are actually doing another, then we are not having a good day. More on the STEM situation. On STEM, you have to work a minimum of 20 hours. So you have to be at least part-time employed. And unemployment is really something to watch out for, whether you are in regular OPT or whether you are in STEM OPT. On regular OPT, which is good for 1 year, as you know, you can be unemployed for up to 90 days in that year. And during your STEM time, which is 24 months, you can be unemployed for up to 150 days. I say this because this is the regulation, but all of you know that the economy in the US is really running very hard at the moment. Nobody can find employees, so unemployment should really not be something during this day and age that you are encountering. By the way, for regular OPTs, if you are unemployed and you are getting close to these 90 days, I suggest that you volunteer, because volunteering counts against unemployment. So you can defeat the unemployment time by volunteering should you really not find a job where you're being paid. So I see there are some things in the Q&A. Let's not wait until the end. Let me just try to answer that. Someone's asking me how long it will take to get an H-1B visa after getting a J-1 visa. I can't answer that. Processing times are completely off the grid at this point. So I have no opinion on that. Sergio is asking us, I'm graduating this semester. I've received an offer in higher education. They promised they will take care of my H-1B visa beginning on August. However, I was wondering if I should still apply for OPT and look for another job in my field or wait for my fall appointment. Sergio, you better apply for your OPT because the H-1B lottery has already run for this year, and you're not going to get an H-1B this year unless you have been chosen in that lottery. And even if you have, there's no guarantee you're going to get that H-1B visa, so absolutely apply for OPT. Here's someone asking, as an international student, if I have my prior degree, bachelor and master in engineering in my country, and I'm now studying management, can I do a STEM OPT with it? Now, STEM's got to be on stateside, not overseas. Hassan is asking us, after 24 STEM extension, is there any visa I can apply for either while in the US or go back home and apply there if my company missed the window of applying for me for sponsorship during March? No, STEM expires in May and STEM expires in July. I would have to know more about your background, Hassan, in order to answer that, but my preliminary answer would be yes, there are other visa categories available. Moving on. So the next visa we're going to talk about is the H-1B. It is obviously the visa that most of you are seeking if you don't have it already. But those of you graduating with a bachelor's degree this spring, the H-1B visa, or if you graduate any time later, the H-1B visa is obviously the visa to go for. The H-4 is for dependents, so H-4 is for H-1 children and H-1 spouses. So the basic prerequisite for the H-1B visa is that you must have a degree. You must have a job offer in what's called a specialty occupation. And typically, whatever your degree says, that is then the specialty occupation. Now, if you have, let's say, a degree in business administration, that's really not a specialty occupation. There's got to be a real name associated with that degree. And NMSU is really great with that. I mean, either you're an electrical engineer, you're a mechanical engineer, you're a soil scientist, you're an animal scientist. Those are the specialty occupations, and among so many others. But the important thing, when you look for a job for an H-1B visa, what's really important is that the degree has to be a direct function of your, that the job offer that you're going to get has to be a direct function of your degree. So if you have a degree in mechanical engineering, but a job offer as an animal scientist, well, that's not going to work. If you're a mechanical engineer, you need a job offer as a mechanical engineer. Another important thing about the H-1B visa are the wages. And on the wages, I want to say the following. In the visa context, we deal with two types of wages. One is called the actual wage, and the other is the prevailing wage. And that's something very important for you to remember. The actual wage is the wage that the employer offers you for the job that you're applying for. And the prevailing wage is the wage that the Department of Labor tells us that you should be paid for the job you're applying for in the area where that business is located. So again, if we take the example of, let's say, a mechanical engineer, you just graduated with a 4-year bachelor's degree and you find a job offer in Las Cruces, and that the employer offers you $60,000 to work as a mechanical engineer in their shop. And we do the prevailing wage, and the prevailing wage comes back with $65,000. Well, you must be paid the higher of the two. If the prevailing wage is higher than the actual wage, you must be paid the prevailing wage. If the actual wage is higher than the prevailing wage, you must be paid the actual wage. So you always have to be paid the higher of the two. But the baseline is really the prevailing wage. I think we got some more questions. I'm gonna postpone those questions to the end. I don't think it's fair to the other participants. Those are advanced questions, completely out of context for what we're currently talking about. But I'll be happy to answer them today for you. So some other things about the H-1Bs. There's some really controversial basics about that. Many of you know that there is only 65,000, H-1B visas available every year for persons who have earned a bachelor's degree, of which 5,400 go to Singapore under a trade agreement we have with that country, and another 1,400 go to Chile, which also under a trade agreement we have with that nation, plus 20,000 visas go to persons who have earned an advanced degree or higher. An advanced degree or higher means a master's degree or beyond. So, I don't know how many visas we really have. I mean, you go and figure that out. But what I do know is that there are never enough visas. So there is this annual numerical limitation on H-1B visas, which is really the problem that so many of us are dealing with. And so there is a cap. The bachelor's degree visas are capped at 65,000, and the masters and higher degrees are capped at 20,000. So the question is, are you coming within the cap or no cap? Any private employer really out there is subject to the cap. But since there are so many visa applicants, and there's always more applicants than cap H-1Bs available, I encourage you to also look at no cap H-1B possibilities at organizations that are not subject to that cap. And those are all institutions of higher education. So if you have a job offer at Nmsu or any other college or university, they are not subject to the cap. So they can apply for an H-1B visa at any time they want to. If you have a job offer at a government research institution or at a not-for-profit research institution, they are also not subject to the cap. So if you have a job offer anywhere of those, then they can apply for your H-1B visa at any time. And then there's a difference between the cap and the cap gap. And I'm telling you, I'm not making these terms up. Those are actually the government terms. And I want to talk to you about what is the cap gap and what is the H-1B registration for all of you who want to apply for H-1B visas. So the cap gap is actually something really good. I told you that the H-1B visas are subject to annual numerical limitations, and they are available every first of the year. And our government year starts on October 1st. So all the visa numbers, the new visa numbers, become available on October 1st. And under our immigration regulations, if you apply for a visa, you can apply for that visa as early as 6 months before you need it. So if all the visas become available on October 1st, minus 180 days, that would be April 1st. So April 1st is then the earliest that you can actually apply for an H-1B visa. Now imagine this. If you have OPT, you graduated in April or May, and you get OPT, and OPT probably starts in June, and your OPT is good for 1 year. So you're in OPT from, let's say, June 1st until May 31st of 2023. And then you want to get that H-1B visa, but your H-1B visa is not going to be available until October 1st. So you have this gap from May 31st until October 1st, where you don't know what to do. Well, that's where the cap gap regulation comes in. So if you have been selected for processing for an H-1B visa, you may continue to work with your OPT from May 31st until October 1st, until you actually get your H-1B status. So that is the cap gap, and the cap gap is actually a very, very good thing, and most of you will hopefully be able to take advantage of that. Now, when you apply for an H-1B visa, it's really the employer that applies for you, and you have to register in order to be able to apply for an H-1B visa. And based on these registrations, there is actually a lottery, and only if your employer is being selected can you apply for that H-1B visa. So this year, the registration started on March 18th, ended on March 31st, and by April 1st, the H-1B visa lottery winners were selected, and you know, we had a number of registrations that we sent out this year, but only 30% of our applicants were chosen. And I have spoken with a number of my colleagues, and everyone is at 30%. So we know that unfortunately this is it. There may be another drawing if not all the numbers have been used, but at this point, only 30% of all the applicants have been chosen to apply for an H-1B visa. And all of those now have 90 days to apply for their visa. Now, in order to register, it's very cheap. It's only $10 to register. Makes no sense from a business sense, but then our government doesn't have any of that anyway. So $10 is all it takes. And it requires a registration account. And the petitioner, that's your potential employer, which is very, very important. Because remember, when you apply for a visa, you are in 95% of the cases, you are the beneficiary of someone else's petition. So you're not applying for anything. It's really your employer applying for that H-1B visa for you. So the petitioner, your employer, they have to provide their legal name, their DBA, their federal employer identification number, their address, stuff of that nature. And you, as the beneficiary, you have to provide your name, degree, your date of birth, country of birth, your gender. I don't know how your gender is so important about the job you're going to do, but this is what they want to know. Your passport number. So very limited information, really, in order to register. So there are more things about the H-1B. Once you finally get your H-1B, there's a 6-year limit on it. So you can't have your H-1B for more than 6 years, which makes no sense in the real world. There is a way to get around that. I will teach you today on how to do that. And you will see very quickly on how important it is that you know how to get around this 6-year limit. What we do know is that if you're in an H-1B, it does not count against H-4 time, and H-4 time does not count against H-1B time. Sometimes I see this with married couples where one has an H-1B, the other has an H-4. You flip-flop and change from H-1B to H-4 and vice versa, and you can actually get 12 years out of that. Sometimes that happens, most of the time it does not. Another good thing to know about the H-1B is that you can port to another job. And I say this again, I'm not making up these terms. This seems to be a term right out of Star Wars, but this is how our government calls changing jobs or switching to another job or getting another job. They say you port to another job. And that is a very, very important thing, because you might get your H-1B with employer A, and then after a few months you find out you don't like it there. It's a bad workplace, or it's not challenging enough for you, and you want to change jobs. And with an H-1B, you can do that. But there are certain things you really, really gotta watch out for, because if you don't, you're gonna run afoul of some regulations and you're gonna not get that next H-1B. So listen carefully what you gotta do. If you have an H-1B and you wanna change jobs, do not quit your current job until you have the other job. And here's what I mean with that. Let me explain by way of an example. If you work for employer A with an H-1B visa and you want to change jobs to employer B, then employer B has to file a new H-1B application for you. There's no such thing as you taking your H-1B with you. The only thing you're taking with you is you have been counted against the numbers again, and you're not subject to the annual cap. So you can change jobs at any time as long as employer B applies for your new H-1B visa. And you have to wait until that new application has been filed and properly accepted by the USCIS before you change jobs. If you change jobs before then, or if you quit your job with employer A before then, you're out. I can't do it. It's not possible. You would then have to go home to your home country and apply for a visa and come back in. So very, very important when you change jobs on H-1Bs, you're leaving employer A, do not leave employer A until employer B has actually filed the new H-1B petition. Now, I told you a minute ago that H-1B visas are only good for 6 years, and that I will teach you on how to go beyond the 6 years. And that's really a very, very important thing. And we find this under a regulation called AC-21. And AC-21 is the American Competitiveness Act of the 21st century. And it was signed by, I think in the year 2000 by then President Clinton, and it's really a very, very good a piece of law. And if you take anything away from today's presentation, it should be this. So here's what has to happen to go beyond the 6 years. If an H-1B can be extended beyond its 6-year limit, if a labor certificate or an immigrant petition has been filed for you at least 1 year, 365 days prior to the expiration of your 6-year H-1B time limit. If that's the case, you can extend your H-1B in 1 to 3 year increments to infinity until you get your green card. Now, again, let me put this in plain English. An immigrant petition or labor certificate has to be pending with the authorities, the Department of Labor or the USCIS, for at least 1 year before you run out of H time. And you run out of H time after 6 years. That does not mean that you should apply for this in your 5th year, because there is a lot of red tape associated with labor certificates. There's a lot of red tape associated with filing immigrant petitions. If any of you have ever applied for anything with the USCIS or the Department of Labor in the last 2 years, they are operating at a sloth pace. So do not wait until your 5th year to discuss with your employer whether he or she is going to file a labor certificate or immigrant petition for you, because I guarantee you it will go back. We will not be timely. You know, you should do this in your 1st year of H-1B, in your 2nd, in your 3rd and 4th year. That's when you got to get going with that immigrant petition in order to extend your H-1B beyond 6 years. And that is very, very important. And you will see later in this presentation on how important this really is. But that is one thing you have to take care of. Do not procrastinate on asking your employer whether they are willing to petition for your permanent residence in the United States. And if that employer is not willing to do it, find another employer. If you want to stay here permanently and your current employer is not willing to petition for you, keep looking. By the way, I'm an employer myself, so I can tell you this is a great time to look for a job. As an employer, I can't find anybody. And any other employer, acquaintance, and associate I talk to, they can't find anybody. Nobody can find good professionals at the time. It's such a tight labor market. So you, as job seekers, you are really in an excellent, great position. It's really an employees market at this time. So let's switch to another visa category that I have found very, very useful at Nmsu, because there are so many talented graduates there. And the O1 visa basically says, you know, it is set aside for the very small percentage of those who have risen to the very top of their field of endeavor. Now, typically you would think that if you just graduate, you haven't risen to the top of your field to your endeavor, but that doesn't mean that you are not a person of extraordinary abilities. And there's only one way to find out, and that's for me to see your resume, and then we can figure out whether you come within this category. And the O1 category is split up in several subcategories. And that's extraordinary abilities in either the sciences, the arts, education, business, or athletics. So here are the prerequisites on that. On the O1, now if you have won a Nobel Prize or an Olympic medal, please do give me a call, because you will qualify for the O1 without more. But since most of us do not have a Nobel Prize or an Olympic medal, you know, we got to qualify otherwise. And that means we have to meet at least 3 out of the following 8 prerequisites. So we want a lesser award. And a lesser award means, you know, some prize that you have received, you know, in your discipline. You are a member in an association that requires membership. So let me be clear about memberships in associations. If you are a mechanical engineer and you are a member in the Mechanical Engineering Association of America, that means nothing, because every mechanical engineer is going to be a member of that association. A membership in a distinguished association means you only get in there by appointment, or you get there by invitation. So this is really what we're looking for. If you're in academia, you got to be published. We all know that, publish or perish. 4, you have judged the work of others. Let me just say that being a TA is not judging the work of others, unless as a TA you have responsibility for the class and you're actually grading papers. Then you are judging the work of others. You have produced some original work, meaning you have a patent, or if you're a researcher, you have some original research. Scholarly authorship. If you're in academia and you're not published in a journal, you're not in academia. So if you're in the sciences and you're not, there's no scholarly authorship that you have published, then you have not reached that O1 level yet. The work you do, number 7, is critical or essential to the employer where you are employed, because your skill set is so extraordinary. Or number 8, my favorite one, you make a lot of money. Look, if you're not paid properly, you're probably not that extraordinary. And I don't want to sound derogatory, but that's just the way it is. So, but you don't have to meet all of it, but you got to meet at least 3 out of those 8 in order to come within the purview of the O1. And I'm very, very pleased to report that we have done many, many O1s for not only NMSU faculty, but also NMSU graduates. If you are a Canadian or Mexican, then the treaty NAFTA may be important for you. It is now called the US-Mexico-Canada Agreement. That is a very, very interesting visa category. And at NMSU, I know we always have Canadian and Mexican graduates. The TM professions, you can just look them up online, just Google TM professions, there's 65 of them, and you have to fall squarely within one of those. And I'm very proud to say that NMSU actually has more TN titles in their degree program than most other universities, since you are by definition an agricultural science university. A lot of the agricultural science professions are actually listed in the TN profession. So this is really exciting if you are Canadian or Mexican and are an NMSU graduate, because you might fall squarely within the treaty NAFTA visa category. Now, if you get a TN, if you're from Mexico, you always get it in yearly increments. Like any other visa, by the way, if you're a Mexican national, this is a reciprocity agreement between the US and Mexico. By law, it's a reciprocity agreement. I call it more like a tit for tat. When US citizens go to Mexico, they only get visas for 1 year. So the US said, well, if Mexicans come here, we only give them a visa for 1 year. I mean, it makes no sense. But that's the way it is. Of course, the TN has a lot of pros. It's an unlimited number available, so it's not like the H-1B, so you can have it at any time. I can apply for it today if you qualify. The cons are it's a strict non-immigrant visa, meaning you can't even think about immigrating to the US if you have a TN. If you have an H-1B, it has dual intent. You can be a non-immigrant, you can be an immigrant, it doesn't matter. So the biggest con about the TN, it's a true non-immigrant visa. For Canadians, by the way, it's issued in 3-year increments. So much for equality there. So I know it looks like elementary school because since this is the alphabet. However, I will tell you, I'm only going to spend a minute on the alphabet because we'll call it the visa alphabet. Because I don't know who you are. I see there's many of you online today, but we can't talk about all visa categories, but there's really a visa almost for every letter in the alphabet. So I'll run through them in a couple of minutes. And if you think you qualify for any of those, contact me separately or put it in the Q&A. So A visas are for diplomats and their spouses, B visas are for visitors, C visas are for people transiting through the United States, D visas for crew members if you work on a cruise ship or if you work for the airlines, E visas are for traders, and I mean trading, and not traitors. So it's for traders. E visas are also for investors, and E3 visas are for professionals from Australia. F visas, most of you have one. G visas are people working for governmental NGOs. H visas we already discussed. I visas are for the international press. J visas, international exchange. Visitors visas, some of you have those. K visas if you have a United States fiance. L visa, intra-company transfer, transferring from an executive from one country to another. M visas, if you want to be an aircraft mechanic, you don't need an F visa, it's for non-academic studies. N visas if you work for NATOs. O visas we just spoke about. P visas is for athletes. Q visas are cultural exchanges. If you're working at Disney World in the Moroccan palace in the World Showcase, well, then you have a Q visa. R visas are for religious workers. S visas we call the snitch visa. So if you know anything about drug trafficking and you want to rat out a drug trafficker, the FBI will get you an S visa, and after that they'll deport you. So not a very good visa to have. T visa, a good thing to have, but a sad story. That's for human trafficking. U visa is for victims of crimes. V visas are no longer available. Ws are for visa waivers. So if you come from one of the 27 visa waiver countries that allow you to be stateside for 90 days in one piece, and there's no visas for XYZ. So if you heard anything that might fit your profile, then do let me know separately. So we just spoke about these non-immigrant visas. We spoke about the TN, we spoke about the O1, we spoke about the H visa, we spoke about the F1, which is what most of you have. And all of those visas we spoke about, they are non-immigrant visas. And a non-immigrant visa is a visa that is issued to you at a consulate abroad, and then you enter the United States in that non-immigrant visa classification. You conduct yourself consistent with the purpose of that visa classification, and then you leave. So if you have an O1, you engage in your extraordinary abilities. If you come in with an F1, you go to school and so on. So that's all temporary. And the IVs are the immigrant visas. And immigrant visas, of course, are permanent. That means you remain in the United States permanently. And there are two main categories. There's a third, which is asylum, which we're not going to discuss today, unless someone has, unless one of you has a question about that. But other than that, it's really divided into family immigration and employment immigration. And what we will do, we will talk about employment immigration, because that is really what applies to you. If you have US family, let me know, we can fix this very quickly, but employment is really your gig here. So anything in the employment context, you recall on the non-immigrant visa situation, we already said that the H-1B visas are subject to annual numerical limitations. Some visas are, some visas are not. In the work world, everything is subject to quotas. And these quotas are published in what's called the Visa Bulletin. And many of you have already looked at the Visa Bulletin. If you have not, then just Google Visa Bulletin, it'll come right up. And there are different categories, and I want to teach you on how these visa quotas work, because that is going to be very, very important for you. So here what you are looking at, we are looking at a page of the Visa Bulletin for May of 2022. So this is actually happening, what you see here. And if I may explain to you, what you see here are three highlighted categories. Those are the red ones, because those are the ones we're talking about. The employment first category, we call EB1. The employment second category, we call it EB2. And the employment third category, we call EB3. This is what we're going to talk about. So the Visa Bulletin tells you whether a green card is available or not. The C in here means current, and current means a green card is available, a green card number is available. So if we look at all countries in the world, which is called all chargeability areas, except those listed. So if you're in any country, it appears to be current, unless you are from mainland China. If you're in mainland China, if you're from mainland China and you're in the employment first preference category, you're current. If you're in the employment second category, the government processes April 1st of 2019. So that's already 3 years behind. In the third category, we're already 4 years behind, April 1st, 2018. Other workers is already 7 years behind. If you're from India, in the EB2, we are processing December 1st of 2014. In the third preference category, we are processing January 22nd, 2012. Think about that for a moment. If you're from India, the employment third preference category is 10 years behind. Can you see now how important it is to act properly under AC-21 to make sure that you can extend your H-1B visa beyond 6 years? Because if you don't, then you are from India, you're not going to get your green card while you wait here. You'll be waiting back home in India if you did not extend your H-1B under AC-21 beyond the 6 years. So that's why AC-21 is so important. And a word of caution for all other nations, if you're from Sweden, if you're from Germany, if you're from Brazil, just because this is current today does not mean it's going to be current tomorrow. I have seen these backlog and retrogress as well. Have I seen that often? No. But have I seen it? Yes. So it is really, really important that you keep this in mind. Once you have your H-1B, and if you want to remain permanently in the US, your employer needs to file that labor certificate or that immigrant petition as soon as possible, so you can extend your H-1B beyond 6 years, so you're not falling victim to these lengthy processing times. So here are those categories again: EB1, EB2, EB3. Those are taken right out. Those are taken right out of here. EB1, EB2, EB3. Those are the ones I want to talk about because those are the ones that really apply to Nmsu, and that's the EB11, the EB12, the EB2, and the EB3. So a labor certificate. I've been talking about you got to ask your employer for a labor certificate. What on earth is it? I'm telling you, it is the most classic way to immigrate to the United States by way of labor certificate, where an employer cannot find an able, willing, qualified, available individual to perform the job duties that are required in the area where that employer is located. That's all that is, simplified. There is no able, willing, qualified, available worker available in the area where the employer is located. And most people really need that labor certificate. So the employer has to do the following. They have to offer a full-time job. And for this purpose, a full-time job means at least 35 hours a week. Remember, with an H-1B, you could be part-time. With a treaty NAFTA, you could be part-time. Not with a labor certificate. A labor certificate is a full-time job offer, and full-time is 35 hours a week. It has to be a bona fide job offer, meaning the job really has to exist. I can't tell you how many calls I get. Look, I got a friend, he's got a business, he can just write it up. No, he can't. It's got to be a bona fide job offer. The job cannot be tailored to the applicant. I can't tell you how many calls I get. Oh, you know, we got to hire Juan because he speaks Spanish and we really need someone who speaks Spanish. It's a bunch of nonsense. That's tailoring the job to whoever it is. Now, if Spanish is really necessary in that job, then we have to prove that this is truly a business necessity. meaning everyone in that business only speaks Spanish, or we are trading with Latin America and all of our counterparts are Spanish speaking only, well, then of course, our applicant has to speak Spanish among having all the other qualifications. But having a language requirement just because someone speaks the language, that is not going to do it. There's also prevailing wage determination. Just like with the H-1B, there's an actual and a prevailing wage, and we have to do a prevailing wage determination. And the employer has to prove that there are no US workers available that are able, willing, qualified, and available to fulfill those job duties. And we do this by testing the labor market. So we post ads in the paper, we advertise on radio, we advertise online, only in the area where the job is required to see whether there is a United States citizen worker. And right now is, like I said, it's a very, very good time to do that because there just are no workers available. So the labor certificate is really something that gets you a green card. And again, you gotta start it timely in order to extend your H-1B beyond 6 years if that becomes necessary. So then we go to the EB-11. Again, those are persons of extraordinary ability in the sciences, arts, education, business, or athletic. Sounds just like the O-1 visa because it is. It's an O-1 visa on steroids. But remember, the O-1 visa is temporary because it's a non-immigrant visa. So you always only can get it for the length of a contract. And if the contract is 3 years, I can't get it for longer than 3 years. But the EB-11 is one of the very few green card opportunities that does not require an employer. In other words, you can self-petition. You don't need a labor certificate, but you have to be a person of extraordinary ability in either the sciences, arts, education, business, or athletics. And here, again, Nobel Prize or Olympic medal is one thing, but then, you got to meet 3 out of 10. Same thing as in the O-1, a couple of more prerequisites though. So 2 more to choose from. Either it's a lesser award than a Nobel Prize. Membership in a distinguished association. There's material published about you. You've been a judge of the work of others. There's some real original contributions of your work to a business. Authorship, exhibits if you're in the arts. Performance in a leading role if you're in the arts. You're making a lot of money. Commercial success if you are in the performing arts. If you're just selling a couple of CDs down by the 7-Eleven or at the state fair, that is not a commercial success in the performing arts. So it is really, having reached the top of your field of endeavor. And again, I'm very, very pleased to report that we have done a number of EB-1s for Nmsu graduates and faculty. So very, very talented environment there. I always bring this up because I want to trigger your ideas, and I don't want you to get discouraged by the high prerequisites. And I'm saying, what do a spine surgeon, a perfume bottle designer, and a mountain biker have in common? And I will tell you what they have in common. I got them all EB-1 green cards, EB-1 green cards without an employer. Who would have? Well, the spine surgeon was really specialized in trauma surgery. The perfume bottle designer, because of the attorney-client privilege, I can't name the companies this man designs perfume bottles for, but if you'd hear any of those names, I mean, you'd absolutely recognize it. And a mountain biker, is a very, very famous guy, but he's a mountain biker. So you can get an EB-1, but you have to reach the top of your field of endeavor. And here we have one in the sciences, we have one in the arts, and we have one in the athletics, right in this very real life example right here. The EB-1-2 is a fantastic category and so fitting for NMSU. It's for outstanding professors and researchers standing apart in the academic community through eminence and distinction. A very flattering wording here, but that's what's required. That is the preamble, the actual preamble to the statutory text. And the prerequisite is 3 years experience in teaching or research in the academic area and 2 out of 6 So look at those things. So it's not very hard to get there if you are actually in academia, and if you are a researcher, or if you are a professor, and if this is the main thing that you do, you could come within the purview of that after 3 years already. So that's really, really exciting. Now, the EB2, I think, is a major category that many of you really fall into, and I get those inquiries from NMSU constantly and all the time. And in the EB2 category, there are really 3 distinct subcategories. The advanced degree, and an advanced degree is a master's or higher. Exceptional ability, and I mean, go figure, you know, there's extraordinary ability and exceptional ability. They're actually not the same. And then there's the national interest waiver. So the first one, the advanced degree, you don't just get that just because you have a master's degree. Not only do you have to have the degree, but the degree must actually be required in the job. And that's often not that simple. It sounds simple, but it really isn't, because the Department of Labor really throws a wrench into that, because our Department of Labor tells us what's required for a particular job. Again, let me use the example of the mechanical engineer. If you are a mechanical engineer and you have an advanced degree and you have a master's degree in mechanical engineering, and you have a job offer as a mechanical engineer, do you fall in the EB2 category? No, you don't. You fall in the EB3 category, because all a mechanical engineer needs in order to get a green card is a bachelor's degree. That's what our Department of Labor says. And you know, with the labor certificate, it's always the lowest denominator. That's the only way to give the American workforce a chance to apply for the job as well. So what is the minimum requirement for a mechanical engineer? Well, the minimum requirement for a mechanical engineer is a bachelor's degree in mechanical engineering, no more, no less. So you having a master's degree in mechanical engineering does not put you into the EB2 category. The job must actually require it. Now, if you, of course, work for an engineering company that is building skyscrapers, and you are supervising the HVAC installations of the mechanical engineering department, well, then you better have a master's degree in mechanical engineering to do that. And here, the job would require you to have a master's degree, and therefore you would then fall or come within the purview of the EB2 category. But other than that, you know, be very careful when you look out at that, because just because you have the degree does not mean that it is required. So that is a very, very important thing. Exceptional ability. This is a very, very underrated category. Not many people know about it. And I encourage you to look at it. We have been very successful in that category. Exceptional ability, you have a degree of expertise significantly above that ordinarily encountered, and you meet 3 out of the 6 requirements here. I really like number 7. It says comparable evidence. Well, as a lawyer, I love it, because comparable evidence, well, now I can bring in the kitchen sink. I can bring out everything out of the woodworks. I will tell you, I got a green card for an exceptional ability person. He was an evaluator of knife handles, because he was familiar with the material consistencies of knife handles with all these fossil tusks and whatever a knife handle is made of. And that required exceptional ability to do that. So gotta get creative on these things, but exceptional ability category is a very interesting thing, but it requires a labor certificate. Also the EB2 requires a labor certificate. Only the EB1 doesn't require one, but the EB2 does, okay? Except when we go to the national interest waiver, which also comes within the purview of the EB2. And again, we have done many national interest waiver applications for NMSU faculty and graduates, and it is really something else. And many people think they fall within it, but then at the end of the day, they don't. So you have to really be careful with the national interest waiver. The good thing is no labor certificate is required, but the proposed endeavor has both substantial merit and national importance. You know, the substantial merit is one thing. I know everything that you do has substantial merit, but it is the national importance that often is overlooked. So whatever it is, it has to be national in scope and not just benefit the city, the county, or the state that you're in. No, it has to benefit the United States as a whole. You also have to be well positioned to advance the proposed endeavor. So just by you having a good idea that might come within the purview of the national interest, if you're not able to execute it, then we can't get a national interest waiver. And then really that unbalance, it would be beneficial to the United States to waive the job offer of the labor certificate requirement. You know, all that sounds good. I will tell you from my own experience, though, I like the national interest waiver, but our government, you know, has managed to backlog the national interest waiver applications so extensively that I can get a labor certificate in the EB3 category quicker than I can get a national interest waiver approved. I mean, it makes no sense. It's completely devoid of logic and common sense, but that's a current fact, that the processing of a national interest waiver without a labor certificate right now takes longer than an EB3 labor certificate. So just something to think about when we embark on your green card. You know, it may be easier to just do that labor certificate in the EB3 category instead of going for that national interest waiver. And then we have the EB3. And the EB3, that's everyone with a bachelor's degree. It's skilled and unskilled labor, everybody. I always say everybody is labor certifiable. As long as there is a job available and that employer can find a willing, qualified, available individual, is labor certifiable. Whether you are an astrophysicist or whether you are a plumber, it makes no difference. If the job's required and the employer can't find anyone, we can do it. I'm going to talk a moment for some other considerations. And I think it's very, very important, and that is social media. And it's a new requirement. It's been up for a couple of years that when you apply for a visa or green card, it doesn't matter what you apply for, you have to disclose all of your social media handles for the past 5 years. And don't even think not disclosing them on that form, because the government already knows about your social media handles once you get to that interview at the consulate abroad or at the USCIS stateside. And it becomes a consideration in visa issuance. So I'm telling you right now, clean up your accounts. I know we just had spring break, or you're about to go on spring break. You know, you hanging out at the beach party where everyone is having cocktails and stuff and party. I don't want the consular officer to see that, because a consular officer will interpret that as you being a habitual drunkard. And this might sound funny, but it's actually very sad, because that's how our government operates. Also, you know, you need to be culturally sensitive. What's funny in your country may not be funny in the United States, and vice versa. So any comment stateside about some other nation may not be funny. You don't know what cultural background that consular officer has. And that consular officer does not know you. But what they do know is what it says on your social media. So be very, very careful of what you post. Be very, very careful of what you like, and be very, very careful of whom and what you follow, because all of it together, it comes to haunt you on a visa issuance. And it's you know, it's incredibly sad that I have to say that. It's incredibly sad that this is a fact, but unfortunately it is this way. So now's the time to clean up your social media, so we can go ahead and not have any trouble at the consulate overseas or at the USCIS when we apply for something. So now you can go ahead and ask me about anything. I will go through the Q&A now, and there's also a thing in the chat. Let me just go through this point by point and answer all of your questions, and you can also raise your hand if you like. Anna Shines is asking, do you recommend to apply for the OPT before or once you have a formal job offer letter? Anna, that's an excellent question. When you want to apply for OPT, you can apply up to 90 days prior to graduation, up to 60 days after graduation. Do not, and I repeat, do not, under any circumstances, wait for a job offer. Don't do that, because there's a small window to apply for OPT, and you cannot start work unless you have that work authorization in hand. It currently takes approximately 90 days or longer to get the OPT issued. So the minute you qualify, meaning 90 days prior to graduation, go see your DSO, get the recommendation for the OPT, and apply immediately. Padma already is asking, can you please talk about volunteering and labor laws? Well, you can volunteer. I'm not sure how it applies to labor laws. If you volunteer, you're not filling a position. If you volunteer, you're not getting any money. If you volunteer, you're just helping out. You're not filling an existing position. If you're filling an existing position, you're actually interning for something very specific. If you're volunteering, you're just helping out. It has no impact on the labor laws. You're not violating anything as long as you're not getting paid and you're truly a volunteer. Adam is asking us, who can I reach out to if I would like your law firm to apply for my H-1B visa? I got selected. Well, Adam, congratulations that you got selected. That's absolutely wonderful. I want you to reach out to Tim Reardon in our Albuquerque office, or at the beginning of this PowerPoint, there's my email address. You can write to me directly, and I'll be happy to get this into the mill. And again, congratulations on being selected in the H-1B lottery. That's absolutely fantastic. Abidemi is asking, when extending your STEM, is it for another 24 months? Abidemi, the STEM extension is a total aggregate of 24 months. So if you apply for STEM, you get the 24 months. If you're changing employers and you need to apply again, it's just adding on. But the total amount of STEM you can get is 24 months. Suhashini is asking, my F1 visa is expired, but I have more months on the I-20 until I finish my PhD. Can I apply for the diversity visa lottery? Will I be considered as dual intent? No, applying for the diversity lottery or participating in the lottery is not a dual intent, so you can go ahead and do that. Once you apply for the actual green card, if you have been selected, that would be a dual intent issue. I know there have been issues in the past where someone said that even participating in the lottery is a dual intent. I'll gladly defend that in any court of law if that were to come up. So those were our chat questions, and now let's go to the Q&A and see what we can answer here or what we have not answered yet. We already answered Sergio's question. Right, as an international student, I have my prior degree, bachelor's and master's in engineering in my country, and I'm now studying management. Can I use that STEM? No, we can't. The STEM has to be from stateside. Hassan, after 24 STEM extension, is there any visa can I apply either while in the US? Hassan, I think, to the H-1B is, of course, something that you can apply for. If you haven't been selected yet, you might qualify for the O1. I think what would be advantageous for us to answer your question more fully would be if we could see your resume. But you seem like a very, very qualified applicant since you are a STEM graduate. So you might come within the purview of the O1. And I'd also be interested if any of your current employers have already, or whether you have discussed with them, whether they are willing to file a labor certificate for you. Ahmed is asking us, I plan to graduate next semester. If I have a STEM OPT, but my passport is due to expire in between the time period, what would be your advice? I don't know what country you're from. Ahmed, get with your embassy in DC immediately and get your passport extended. There's a possibility that your STEM stay is only given for the duration of your passport validity. So please get with your embassy in DC. Hassan is asking us, I'm from Saudi Arabia. What are the other visa options you said I can apply for to continue working? Again, Hassan, I think I just answered that a minute ago. Eduardo is asking us, does a postdoctoral position count for an H-1B visa? Absolutely, it does. Saide is asking us to get postdoc position. Should I be on OPT or J1 or F1? I'm currently an F1 student visa. Either the J1 or the F1 would work for, or the OPT would work for them. For that, I would prefer the J1 on that, depending on what country you're from, to make sure that you're not subject to the 2-year foreign residence requirement. The OPT will definitely work for that. And then, of course, it is also an H-1B possibility, since this would be cap exempt if it's on campus. Hashem is asking us, if I get funding for my startup, what immigration options do I have to work for my company? Does funding and patents help with an O1 visa? An O1 visa is a non-immigrant visa, Hashem. It requires an employer, so you cannot be self-employed in your startup with an O1 visa unless your startup has a board of directors that has the authority to fire you and actually to employ you. So I would need more information on that. I recommend that you reach out to Tim Reardon or to me directly, so we schedule an individual consultation on that. That seems to be somewhat more involved, Hashem, that question, and goes a little outside the perimeters of this presentation here. Ahmed had another question, just to confirm, being a TA qualifies one for an O1 visa. No, Ahmed, that's not what I said. What I said that a TA about judging the work of others, that's when I brought up the TA, and a TA typically has another sort of visa. TA is typically on an F1, but judging the work of others only qualifies the TA if the TA actually has responsibility for the class. I don't think that a TA is a person who has reached the top of their field of endeavor, and a TA, in my opinion, without more, would not qualify for an O1. Hashem appears to have another question. I'm currently on an F1 visa in the US. Can my brother, who is a United States citizen, sponsor my change of status? Theoretically, yes, but that would be a family fourth petition. Those are backlogged for over 10 years. So that would not make a lot of sense. It would make sense to file the petition immediately so the clock starts running. There are only 23,400 green cards available in the family fourth preference petition, and those really move very slowly. And so we would have to find, Hashem, we would have to find, a status for you to bridge that gap until your brother's petition actually becomes current. Hassan Mouzadeh is asking a question. I'm in the 3rd semester of my PhD program. I have an F1 visa. A 3-year-old Dallas-based startup IT company has offered me a 45% share of the company in exchange for ownership of some of my past work. Am I allowed to be the owner of a startup company and receive profits while being in F1 status to keep my funding to finish my PhD? Also, the company offered me a full-time position for which they are ready to apply for E2 status for me, but I'm not interested to work and prefer to finish my PhD. Well, first, congratulations on finishing up your PhD. The rest of it, Hassan, I don't like it. Again, congratulations on the super offer that you have, but I don't like it at all. This is a clear violation of every visa rule and labor law rules. Please reach out to Tim Reardon for a courtesy consultation. I want to discuss this with you in detail. There's too much involved in that to discuss it in this forum. But I want to make sure that you're not going down the wrong path on that. There's a question from someone anonymous. As an international student with an F1 visa, can I apply for an NIW, which is National Interest Waiver, during my graduate program without having any problem with my student status, irrespective of the application outcome? Respectfully, anonymous, that question makes no sense. I would really have to get some more details on that. I mean, how do you qualify as a national interest waiver? What are the details on that? I'll be happy to answer that if you provide your name and contact information, and also if you provide us details as to why you think you qualify as a national interest waiver specifically. I would like to see your resume. Let me see if there are any other questions. These appear to be all the Q&As that I see. It seems we have answered everything. So with this, I really thank all of you for participating today. Again, I will make this PowerPoint available to NMSU. You can also you will also be able to find it on my own YouTube channel, which is immigrationhelpchannel.com. That's immigrationhelpchannel.com. I will post it there in the next couple of minutes or so. So if that helps you, feel free to view it there or download it from there. And again, let me say this: everything that I said today, especially in the Q&As, those were specific to the questions that were asked. It may not apply to someone else. And all the other information that I provided you, please remember that immigration is a moving target. It changes daily. And if you intend to act on anything that you heard in this seminar today, then please do reach out to us first so we can advise you properly so that you're not doing anything wrong. As you know, as NMSU students, as NMSU faculty, as NMSU staff, we provide you courtesy consultations. So we'll be happy to discuss those personal issues with you and get you onto the right visa and green card track. And with that, I thank you for participating today and thank you for allowing me to present to you. And I look forward to speaking to all of you soon again. And that concludes our presentation today.